The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. This morning, we have 3 cases to be submitted to the court. The first case is in the matter of the guardianship and conservatorship of Jorgensen versus Wheatley. Second case is Xenia Rural Water District versus City of Johnston. And the third case will be submitted without oral argument, Iowa Supreme Court Attorney Disciplinary Board versus Whittison. We'll start with the first case. Let's see. Mr. Martin, do you want to check your audio here? Make sure it works.
Testing 1, 2, 3. Testing 1, 2, 3.
Thank you very much, Counsel.
Thank you. And then Mr. McAfee, would you like to check yours as well?
Good morning. Testing.
Thank you very much. I can hear just fine.
Thank you. And it looks like the further review application would be you, Mr. Martin. You may begin.
May it please the court. I'm Leo Martin from the Peters Law Firm in Council Bluffs, Iowa. I'm here representing the executor of the estate of Marvin Jorgensen. Marvin was the protected person in the guardianship and conservatorship proceeding that led to this appeal. In that case, I was the court visitor, formerly guardian ad litem for Marvin, until he passed away on February 7th of this year. This case involves 3 main matters: property, process, and protection. It is important for the court to clarify the definition of property, to also make sure that conservators and courts follow the process laid out in Iowa law in order to protect the interests of the persons who are subject to conservatorships. We need to have the court provide this clarification of property law and then reverse the Court of Appeals decision and affirm the district court. These matters need to be done because the leases that were submitted include gifts. The discounted rental rate and the multi-year features constitute gifts that are a transfer of a property interest of the ward, and those trigger the process under Iowa Code Section 633.668, which was not followed until possibly being followed in the order entered by the district court. Also, the district court never approved specific terms of leases as required in the probate code sections 647 and 652.
Counsel, on that point, what are we to make of the approval that the court entered prior to these leases?
There was an application and an order entered in June of 2017 that was basically a blank check type order, but the guardian ad litem had stated that he consented provided that appropriate weight was given to Marvin's past practices and provided that the conservator did not breach its fiduciary duty. I have taken the same position as the previous guardian ad litem, which is erroneously stated in the Court of Appeals opinion, but the fact that the leases contain gifts in the form of discounted rates does not allow that previous order to be sufficient to govern these leases.
Here's my concern, Mr. Martin. I found the Court of Appeals decision maybe a little bit extreme, that, you know, a contract is a contract and cannot be re-examined no matter how unfair it may be to the ward. On the other hand, it seems like you're saying anytime there is an agreement for lease of farmland at anything that might be less than the market rate, that has to be treated and specifically approved as a gift. And that seems like maybe a change in the law. I mean, the situation of a below market lease to a relative is not at all uncommon in Iowa, is it?
It is not uncommon, and an individual has a right to handle their property the way they want to. But once a person is subject to a conservatorship, we have to look at the process outlined in the Iowa Code. We also need to look at the well-settled law from the U.S. Supreme Court that a transfer for less than full and fair consideration is a gift. That was decided in Merrill versus Foz, 324 U.S. 308 at page 312 in 1945. There's also an Iowa Code definition of gift set out in 68B.2 sub 9. And then the U.S. Supreme Court in Dickman versus Commissioner cites situations where leases at discounted rates are also gifts. That case actually involved interest-free loans of money, but that use of the money was also considered property. The Dickman case decided by the U.S. Supreme Court is at 465 U.S. 330 at page 336, decided in 1984. The court does not need to reach the reformation argument if it finds that these leases included gifts and if it finds that the court had not given approval of specific leases as required by the statutory framework prior to the April 27 order in 2018.
Counsel, did the court's approval, the first approval, include the specific terms that are issued here, specifically the $40 discount?
No, it did not. And we have a situation here where the appellants have been stating that the gift or the leases at $40 below the average ISU rate was the past practice of Marvin, and that is not the case. If you will look at appendix page 587, that outlines the Wheatley's lease terms. They had a lease that would be renewed each year by negotiating and settling with Marvin. There was no 13-year lease approval. There was no gifting at the rate that is set out in the lease that is subject to this appeal.
So how do we square that with the family recommendation to the conservator? And I thought all the children had agreed that that was past practice and that was the rate that they were going to agree to.
That was a recommendation. It was not part of the actual family settlement agreement. And the family settlement agreement said that the conservator still had to abide by it. It could not contravene its fiduciary duty, and it was to give appropriate weight to the past practice of Marvin. But it became clear when they drew up the leases that that was not, in fact, the past practice.
Well, here's what it says. It says that the $40 per acre discount will continue as per past course of dealing. And that's signed by Roxanne and Michael and Mark Jorgensen.
That is what they stated when they signed the recommendation. But the court record clearly shows that Mark and Michael recanted and said that was not, in fact, their practice. And as I stated before, the appellants at page 587 clearly show that that was not the practice. They describe their lease as a profit share arrangement that was adjusted from year to year based upon profitability. And so,
Here's another concern, and I'm following up on Justice McDonald's questioning. I understand we're not talking about your client, but Mark and Michael agreed to the $40 below market, it appears, and then time passes and they don't like it anymore, so they come in and ask the court to change it. That seems to have bothered the Court of Appeals, and arguably, to that extent, shouldn't a deal be a deal?
that clearly did bother the Court of Appeals, but the testimony that was provided in the two-day trial indicates that that was not factual. The district court needed to have the ability to reform a lease if it was actually approved, but it needed to address the situation where people who had the knowledge of what was the actual past practice concealed that, did not give the correct information, and tried to get sweetheart deals to benefit themselves.
Counsel, did the district court make any finding that there was fraud here?
District court did not go as far as to actually show that all elements of fraud.
And did the district court make any findings as to credibility of either Roxanne or Mark or Mike?
I do not find that the court specifically stated that it made findings, but the court did appear to follow very closely along the lines of the analysis that the previous guardian ad litem had in the guardian ad litem statement in appendix pages 580 through 584. And in that analysis, the guardian ad litem was summarizing much of what had been stated. It appears that the court was adopting it, but not specifically stating it within their order.
So with respect to the reformation of contract issue, it seems to me at least that that family recommendation precludes relief on that grounds. I mean, to the extent that we use reformation to try to reform a contract to more accurately reflect the party's intent at the time of contracting, at the time they contracted, they represented $40 discount was the practice, and that's what they wanted to achieve. And the fact that Mark and Michael changed their mind after the fact doesn't strike me as relevant to the reformation question. Do you agree with that?
I don't think that the court has to get to the reformation argument because the fact that the leases were at discounted rates triggers a different statutory process under 633.668, and that requires that the court find for good cause that a gift should be made and an order is entered, and the
But
analysis.
let's assume that we do have to reach the reformation issue. Then the party's expression of intent at the time of the family settlement agreement and the family recommendation, doesn't that control the intent for purposes of determining the intent of the contract?
If you have a conservator who does not understand what the actual facts are because the correct information was not provided to the conservator, and in this case, you had Marvin Jorgensen owning 18,000 acres of land with no written leases, so the conservator was handicapped in not knowing this. I think that in that case, you have one party who does not know what the actual facts are.
Counsel, has the argument on gift been preserved for us? Did the district court rule on that?
That issue was presented. The district court did indicate what it would provide as a discount rate of $25 below fair market value. that remedy is in fact a gift. So yes, I believe it was preserved.
I mean, let me try to home in on what, where I am, Mr. Martin. I'm troubled by the idea that Mark and Michael can kind of change their mind and renegotiate. On the other hand, I'm troubled very much by the Court of Appeals notion that when there's a contract that the court somehow loses the right to supervise and amend as new things develop. It seems to me the ward, the GAL, should not be necessarily bound once and forever by some contract with an insider, which is what you have here. So how do we, if those are two kind of principles that I might have, how would I address this case?
I
You
think
can help
that
me
the
out.
guardian ad litem clearly states that there could not be a contract because there was not a meeting of the minds. Please refer again to the guardian ad litem statement at Appendix 580 through 584. And the guardian ad litem did his best to protect the ward's interest by raising this issue, stating that these leases involve gifts and that analysis needed to be completed by the court. And so I do believe that the guardian ad litem raised it. The court needs to have the ability to correct this. If the court doesn't have that ability, then basically once a family member can figure out how to get initial approval of a deal that's very favorable from them, you're basically telling the district court it has no authority to undo the ruse.
But in that instance, isn't the remedy just a cause of action against the conservator for breach of fiduciary duty? It's not as if the ward is without remedy. Right? Why do we need to undo contracts to provide a remedy when the remedy is an action against the fiduciary?
I'm not certain on that. I don't think you get to the Reformation argument if you apply the other provisions about gifting and about the process of approving specific terms.
You may
if you do-
summarize. So you may summarize, and then we'll move on.
I want you to remember that property, a process, and protection, you need to give clarification to the court. We ask that you reverse the Court of Appeals and affirm the district court.
Thank you, Mr. Martin. Mr. McAfee? Yes, you may.
Sound okay? All right.
Yes, it's fine.
Thank you. May it please the court, counsel. I'm Eldon McAfee, and my partner Julia Vescotial and I are here today representing Roxanne Wheatley, Dallas Wheatley, and Rick Wheatley. And you have much of the background of this case already. What I'd like to start with is, in preparing for this argument today, several things came to mind for me, amongst others. But one thing is, at this stage of this litigation, I'm not sure what can be said or what can be written that hasn't already been said or written, but that's our job here today. I often tell clients, you know, when a lawyer tells you something is interesting, watch out. Hold on to your pocketbook. Because this, when it's interesting, it means maybe the law isn't real clear, or maybe there's some ambiguities in what we need to decide or to talk about today. And I believe this case does have some interesting issues, and you have already uncovered a lot of those in Mr. Martin's argument. But what I'd like to start with is, number one, to me, this case is a bit unusual for a conservatorship case in that there was a mediation and a family settlement agreement. You've discussed that. We truly believe that should be honored. Secondly, the guardian ad litem is claiming that there was misrepresentation in that family settlement agreement and that therefore that should not have been approved as the leases. But as this court has noted, the misrepresentations have come from two of the participants. The third participant, my client, Roxanne Wheatley, has not been found to have committed fraud, deceit, duress, misrepresentations. Those were by the very people who are here claiming they want it set aside. That seems a bit ironic to me. Also, the guardian ad litem attacks these leases as, okay, $40 is too much, but $25 is okay. If we're really looking at whether gifts can be made here, why is the $25 okay? Now, I understand there are some differences that Mr. Martin has pointed out in the process.
Counsel,
Yes.
have these leases ever been approved by the court? I get that the court approved in concept the right for the bank to enter into these beforehand, but was there any approval afterward?
Your Honor, the short answer to your question is no, but I'd like to explain, of course. The terms in the leases, according to my timeline, were actually signed in August of 2017, which is a bit unusual when the ground has been farmed since March 1, as we do farm leases in Iowa. But the terms in those leases that are at issue, the 40 versus 25, that was in the family settlement agreement that was approved back in February. So there's nothing new in those leases.
And counsel, can I clarify that point? Those specific terms were before the court in February, right?
Your Honor, that is correct.
Okay.
Now, I know I wanted to make sure I addressed your question, Your Honor, that the court did not approve those leases after they were signed. That is correct. And that's when it went to the hearing. But this case is so much different in that the court had approved the family settlement agreement, which contained the recommendations, and approved it as presented to it by the conservator. And that occurred in February.
Mr. McAfee, let me, following up on the question I was asking Mr. Martin, let me give you a hypothetical. I know it's not this case, but you have a ward conservator. The conservator agrees to lease all the ward's farmland to the conservator's son until 2030 at $10 an acre, all right? And that lease is signed, it's approved by the court, and then time passes and the conservator comes back to court and says, look, the ward is in trouble, he needs more money, we can't, it's got to be more than $10 an acre. Are you saying that a contract is a contract, the court can't do anything about it?
No.
Then why can't they do something about it here?
Because what they were doing here, Your Honor, was not the situation you just described. There were clearly, the court was aware there are substantial assets in this estate, around $50 million. So we don't have an estate under 668. The conservator can look at that as to will it put the ward's assets in danger by making gifts. If what we have here is a gift, we don't have that situation here. If that situation were present, I believe a court can step in. Now you might say, wait a minute, again, I believe the difference is factual. Now, the Court of Appeals did say they did not believe that the court could step in. And here's the way I look at it, Your Honor. I believe here, one, there was no fraud, deceit, duress, mutual mistake, etc. I believe in the hypothetical you just gave me, that wasn't present either. But at $10 an acre, I guess the way I look at the case law in .641 is it similar to an administrative agency decision? I realize we're not here under 17A, but Is there a certain standard where the court says, wait a minute, even though the conservator approved it, and I believe your hypothetical is where the conservator later finds out it's wrong, but I believe there's a certain standard there where the court could step in and maybe under an arbitrary and capricious standard or something like that. And I realize that's not in the probate code. And believe me, the Honorable Judge Klotz reminded me years and years ago when I was a young attorney, your future, Mr. McAfee, may not be in probate. But anyway, we have to look at what courts can do to address a situation that is way out of line.
But Counsel, here, haven't Mark and Mike admitted that they committed fraud? I mean, at least haven't they said that what they'd previously said wasn't accurate as to the amount of the discount?
Yes, I believe they have, Your Honor, but I say set aside their leases then, the district court have. Don't set aside and change the rate in Roxanne Wheatley's because there was no finding of fraud or deceit on her part, and she did not admit to anything. And in fact, it's in the record that Mark Jorgensen testified at the hearing that he had heard Marvin Jorgensen say that he was that a discount of $25 to $50 an acre was something he had contemplated. I may not be stating that exactly right, but it's in the record that Mark Jorgensen testified that Marvin had mentioned that.
Let me ask the follow-up then. Are these gifts that need to be separately approved by the district court, and did that happen?
First of all, well, that did not happen here as counsel has described it if they were gifts. But before we get to that, that is obviously something this appeal has been, both here and before the Court of Appeals, it has been strenuously examined. We do not believe they were gifts, but I can see the argument of the transfer of an income stream under the Internal Revenue Code. I can see that argument. But 2 points there. Number one, and I don't see anything in the record where there are any gift tax returns filed here, either by Mr. Jorgensen or by the conservatorship. Now, again, I don't see anything in the record that says they weren't filed, but the record is devoid of any of that type of evidence. But also, the way we look at it, if the conservator had not applied to the court to approve the family settlement agreement, we may have a problem there if they are gifts. But the conservator went the extra mile and applied to the court. And so I don't believe, and we don't believe, that the determination of gift versus non-gift is, it may be important to some, but here I don't believe it determines this case because even if they are gifts, I know we didn't have court approval of the leases themselves, I understand that, but we had court approval of the family settlement agreement with these exact terms that are at issue. So there was court approval there that I believe meets the requirements of 668 if they are in fact gifts. Okay. I think what we have here, and one thing I want to make sure we point out, it has been briefed extensively by the guardian ad litem that, when it went to, the conservator is the one who asked for the hearing to approve the leases after they were signed. And it's been stated that the conservator believed that they had violated their fiduciary duty. But take a look at, if you would please, the statement by the conservator's attorney. There was a hearing on a motion to reconsider by the conservator and by Ms. Wheatley, and the conservator just wanted some clarification on some of the terms of the court's order. But there was a statement made at the hearing on May 18th. The conservator's attorney, not the conservator himself, but the attorney for the conservator said, the conservator is not adverse to the leases as they are. The information was received from the families. The family agreement was put forth. The family agreement was followed. There are scrivener's errors in the lease which are minor and which can easily be adjusted so that the conservatorship has no issues with the leases. That's, again, in the record on the May 18th hearing. I realize I think what we have here is the claim that the conservator believed it had violated its fiduciary duty and was asking the court to, in effect, take steps to maybe change the leases. That's not what the conservator was asking. The conservator, because of some contact that the conservator had from the other two family members about terms for cornstalk grazing, et cetera, in the leases, even though the other two family members had signed those leases that made it clear they were to pay for cornstalk grazing, they raised issues. The conservator became concerned and stated somewhat concerned, I may not have the exact language here, about violating fiduciary duty. But there was no finding that the conservator violated their fiduciary duty. And in fact, this statement was made in the hearing on the motion to reconsider that the conservator is not adverse to the leases as they are. I believe I've concluded the remarks I wanted to make. If the court has no further questions, thank you.
Thank you, Mr. McAfee. Mr. Martin?
Your Honors, I do want to clarify that there were findings as to credibility contained in the April order that is the subject of this appeal, not necessarily on the particular issue that was raised in the questioning, but there were credibility issues where the court does find that the sons were credible in their testimony. I do also want to direct the court to the statement of counsel of appellant Roxanne Wheatley at page 587, which I think shows that the Wheatleys also had misrepresented their past arrangement. I think it is correct that Mark and Michael had admitted fraud, but at 587, Wheatley's attorney says, Rick and Roxanne Wheatley advised the conservator of their previous rental arrangement with the ward, which was a type of profit-loss share lease arrangement, under which arrangement, depending on the profitability of the farming arrangement, Rick and Roxanne would pay higher or lower rent from year to year. That arrangement was the past course of dealing between Rick and Roxanne Wheatley. That does not show the discounted rate that was said to be in the specific terms of this lease. It does not show a 13-year lease. There were annual leases.
Mr. Martin, I want to return to the issue of whether or not the probate court or district court has the authority, independent of statute or a common law reason, to rescind or reform a contract. And is that your position, that the court always has the authority to rewrite a contract?
No, I do not think that is an always available opportunity. And I do think that, for instance, the non-family member leases that were submitted for approval, guardian ad litem consented, orders were entered, those cannot be modified. But the leases that were presented to the court for the first time in February of 18 and whose terms were specifically rejected by the court in its April order, those were never valid. And so if they were never valid until there was an approval, there's nothing there that needs to be reformed.
And is that argument contingent on a finding that the leases were gifts? If we conclude they were not, then what is the statutory authority to rewrite the contract?
It can be either on gifts or upon the lack of compliance with the probate provisions that require specific approval of the leases.
So, counsel, in this case, if the district court, if the leases had been presented originally and then approved by the district court, and then the whole issue about the corn stalks rental not being right, and then they went back to the court to fix that part of it, and then, as my understanding, at least, that's kind of when Michael and Mark brought up that they thought that the $40 wasn't accurate either. If those leases had been approved, but then there was a subsequent hearing, would the district court have been able, in this case, to then rewrite those leases?
I think if there had been the process of approval of specific terms and all parties had notice, and Michael and Mark had not raised that issue, it would be too late unless they could establish all the requirements of reformation. I think it would be very difficult for them to do so, but
Is it, I mean, is it your view that if a contract is entered into that is in breach of the conservator's fiduciary duty, the court, upon discovering the breach, assuming the contract is with an insider, can fix it? Doesn't have to wait for, it doesn't relegate the ward to the only remedy being to sue the conservator for a breach of fiduciary duty. Is that your position?
I think that should be the position.
And their position is that on these facts, there wasn't a breach, I guess. Is that
And
my
yet,
understanding?
that appears to be their position, but when the conservator applied for approval of the family member leases, appendix page 311, paragraph 19 says that the court should review and determine whether, by giving deference to the family recommendations and to the ward's past course of dealing, the conservator will be deemed to be in compliance with its fiduciary duties. Then on direct examination, the trust officer admits that they were in breach of their fiduciary duty. Please see the transcript.
What specifically was the breach of the fiduciary duty, right, that he was referring to?
He was referring to leases that were at below fair market rate.
Just in general. So even, so the $25 also would have been,
Yes.
that would have been a breach as well. So we're just
That would have
talking
been
about agreeing to something less than market value is a breach of a fiduciary duty. That's what we're saying? That's what you're
If-
referring to?
In the absence of a showing of good cause and a court order pursuant to Iowa Code Section 633.668, yes.
I have one question, final question, I guess, about remedy.
Yes.
As I understand your argument, what you're saying is that without proper presentation of the leases to the district court for approval, the contracts were void. And if that's true, why isn't the appropriate remedy here rescission and allow the party to renegotiate leases at arm's distance rather than reformation and forcing terms on the parties that nobody ever agreed to?
I think another alternative for the court is if it does not believe that there was a sufficient finding of a gift, it can remand for further clarification or further findings, or this court has the power under de novo review to do the gift analysis and determine whether or not the $25 per acre or it could be another number would be permitted.
I guess my question is why isn't the remedy rescission? You're saying these contracts are void, but you want us to just uphold a contract with terms that the court created that nobody's ever agreed to. So why wouldn't we just void this all and let the conservator negotiate leases with whomever?
I would think that would be a possibility. It would require you to remand to then go through the process of approving those leases.
You may sum up.
I do believe that the court needs to provide direction to show that discounted leases are gifts that require the statutory approval. I ask that the court reverse the Court of Appeals and affirm the district court. Thank you.
Thank you. Case of guardianship and conservatorship of Jorgensen versus Wheatley is hereby submitted. We'll have a pause here while the attorneys exchange or change tables, and then we'll resume.